There are situations in claims when an injured worker can handle their claim without an attorney. These are situations such as minor injuries, injuries that do not result in permanent restrictions or a permanent injury, limited medical treatment. However, there are certain types of claims where I feel strongly that someone not only needs to consult with an experienced attorney, but needs to retain the attorney to help conclude their claim in a manner that is fair and just. The first type of claim, when someone needs to retain an attorney, is when the injured worker, after they're through with their medical treatment, will end up with permanent work restrictions that will prevent that worker from returning to work at their previous position. And this is a situation where someone, a worker, may either lose their job or be asked to go back and perform another position that they were not doing before. In this type of case, the insurance company can require the worker to participate in what's called vocational rehabilitation. And this is an attempt to try to find the worker another job with another employer that is within their work restrictions. There's going to be a vocational counselor that's going to be retained by the insurance company whose job is going to be to help find that injured worker another position. In this case, the rules change, and there is a lot of pressure for the injured worker to find another position. That's why we meet with the vocational counselors to make sure that all the rules are being complied with, and that the vocational counselors are not identifying jobs that are not appropriate for that worker. Whenever a workers' compensation case is going to be resolved by what's called a clincher agreement, the injured worker needs to be represented. A clincher agreement is basically a global settlement that the parties enter into that will end the claim. Once the injured worker signs the clincher agreement, the employer's obligation to pay for medical treatment, pay wages, pay for any permanent disability is over. Whenever a case is going to be resolved by a clincher agreement, the insurance company and the employer will hire their attorney. The attorney's job will be to protect the interest of the insurance carrier and not the injured worker. I feel strongly that whenever an employer retains an attorney, the employee needs to be on a level playing field with the insurance company. They need to have their own attorney who is looking after their interest and is not going to let them enter into an agreement that's not fair, that doesn't pay them each and every benefit that the workers' compensation carrier is obligated to pay. We do not let our clients enter into unfair agreements. Whenever there's a third-party claim, an injured worker needs to have their own attorney. A third-party claim is when the accident or the injury is caused by the negligence of another party. And by that I mean the negligence of someone other than a co-employee or the employer. The best example of this is when someone has to drive as part of their job. And if they're in their vehicle and involved in an automobile accident that's caused by the negligence of another driver, they will have a claim against both the workers' compensation carrier and the liability insurance carrier insuring the at-fault vehicle. So there's two different insurance companies involved, and the rules get complicated. I do not believe a worker can effectively and fairly resolve both claims in this situation. The last type of claim is when an injured worker is receiving both workers' compensation and Social Security disability. In this case, there are federal rules involved that affect how a case can settle. And because the rules get complicated, if someone enters into an agreement without being represented, they could lose valuable Social Security and Medicare benefits.